Welcome. My name is Jeff Steiner. I'm the Executive Director for the Dad's Resource Center. This is the second informational video that we've developed for those who have been served a PFA by the courts here in Center County. With me today is Judge Kelley Gillette Walker, who will help to explain the process from the point at which someone is served with a PFA to the initial hearing in front of a judge. She has been a magisterial judge here in Center County since 2014. Prior to that, she had her own private practice before being a shareholder with the Mazza Law Group and also serving as an assistant district attorney here in Center County. Welcome, Kelley.
Thank you, Jeff. It's nice to be here with you.
All right, well, let's get going.
Okay.
You've been served with a PFA. What comes next?
There will be a hearing in the Court of Common Pleas. It will be scheduled generally within 10 days, sometimes sooner, sometimes later. If you wish to challenge the PFA, you must attend that hearing. And if you wish, you can get a lawyer to represent you. And if you're interested in a low-cost lawyer, if you go to the court administrator's office on the second floor of the courthouse, they have a list of low-cost lawyers that can represent people in PFA hearings.
Okay. Now, what happens at a protection from abuse hearing?
It's like any other hearing. The person who wants to get the protection from abuse will have to testify. They will be sworn in by the judge, meaning they'll raise their right hand and they'll say that they will tell the truth. And they'll give their side of the story or why they want to get the PFA. You or your lawyer get to then question that person on their testimony or what they're telling the judge. After the protected person is done testifying and done presenting their side of the case, it's then your turn. And you and your attorney will talk and decide if it's in your best interest to tell the judge your side. And if you do, you'll get on the stand, you'll take the oath, and you'll testify. At that time, after you're finished, the protected person will then, or their attorney, will ask you questions. And this is all done under oath with the court reporter there. Now understand that the court reporter is there to record everything that's being said. And it's very important that you get a good record of what's being said in case you have to appeal the case or anything comes up later if there are any questions.
Okay, all right. Now, if there is a protection from abuse order, it's often a very emotional, possibly contentious time. How should people conduct themselves or act during the hearing?
It's very important to primarily be respectful to everyone. Above all, be respectful. Everybody there has a job to do, and everybody there wants the best outcome for everybody. So don't interrupt anyone because, again, there's a court reporter who's recording everything that's being said, and they can't record two people talking at once. And don't shout, don't yell, don't shout out when someone else is testifying because not only does that reflect poorly on you, again, it creates confusion with the record that's being created.
Okay. How is the hearing concluded?
The hearing is concluded with a judge rendering a decision or deciding granting the PFA or denying the PFA. If the judge grants the protection order, then that means that you may not have any contact with the plaintiff, the protected person, possibly children, possibly other people. If the judge denies the protection order, then that means that nothing happens. You continue on as you were before. There are no restrictions on you.
Are there times that people settle or make decisions before the hearing that you wouldn't have a hearing necessary?
Yes, the judge generally gives each party the opportunity to talk or have their lawyers talk before the hearing to see if there's something that they can work out. Sometimes they are able to work things out. While there may be a protection order granted, it may be a little less stringent than one that a judge would grant, meaning that there could be limited contact for purposes of raising your children or if you're going through a divorce, possibly disposing of your marital assets, things like that.
Okay, all right. Now, if a PFA is granted, is that the end?
That is not the end. You always have the right to appeal. So, if a judge would grant the protection order and you and your lawyer disagree with it, you may take an appeal of that order. And there is a specific timeline that you have to follow. Your lawyer would know that. But that's something that you should definitely talk to your lawyer about and see if that's in your best interest.
Okay. And you had just mentioned it, but one consideration that often is overlooked is if there are children involved.
Yes.
What if that is the case?
If there are children involved, sometimes the judge will further issue orders with respect to their custody. The judge could restrict your custody with them, unfortunately. The judge may not restrict your custody with them. Understand that you and your lawyer should go back and talk and regroup after the protection hearing and see if a custody action is something that you should file in court to have a judge of the Court of Common Pleas further look into and make further orders on.
Okay. Now, in your years serving on the bench, serving as a district attorney in private practice, you've seen a lot of situations with protection from abuse orders.
I have.
Their courts are often very hard or difficult on people who violate the orders.
Yes.
What are some of the knots, the things that people should not do to avoid violating a PFA?
Absolutely, under no circumstances should you ever contact the protected persons in the protection order. And by contact, that means in any way, shape, or form. You may not talk to them in person, on the phone, via email, text message, Instagram, private message, any type of social media. You may not send a smoke signal to that person. You may not have someone else talk to them on your behalf. Or try to get information from them, have the children pass messages. That is strictly forbidden, and that will get you in trouble faster than anything and land you places that you don't want to be. You may not, contact is just a no-no. Do not send anything. Do not try to send gifts or flowers. That's also a violation.
How about social media?
Social media is absolutely a no-no. Facebook, Snapchat, whatever it might be, you may not yourself or anyone else contact protected persons that way.
Okay, all right. Any other thoughts?
It can be a frightening process, but if you understand what's going to happen, I think it might be a little less frightening. If you have a lawyer representing you, they can also help guide you and help you understand what's going to happen and what different things that the judge says or orders means. And just remember that this is not a final thing. It's always temporary, and even though it may last for a certain amount of time, you will get through it.
Okay, all right. Very much appreciate your time in coming here today to be able to provide this information. It's very important, if you have been served with a PFA, to take a step back, take a breath, gather all the information you can, like this video, and come up with a plan. Make sure that everyone is safe, and make sure that you're not doing anything that's going to violate the PFA. So, thank you very much.
Thank you.